Fifth case from daily list item 5, WPC 5805 of 2017.
Just a moment. There are two more cases. Mr. Lai, please come. And there is one more case whether it can be deferred for permanent body dealing with dispute. Where is ASJ? Where is ASJ? Mr. Lai, where is the other side? Are you there? Okay. I have given the dictation in my chamber. All can enter this. Your arguments were already recorded.
Item 4 from supplementary list, WPL 5248 of 2019.
Just two judgments. The judgment that was relied by the learned senior, my senior, I would like to distinguish this matter.
You have already distinguished it.
No, I did not have that judgment. The judgment of Honorable Supreme Court 2001-6 SCC 222 that was relied on.
Yes.
The paragraphs that were relied upon by the learned counsel for the petitioner were paragraph 8, 9, 13 and 15. But paragraph 5, 6 and 7 would be relevant why the delay and laches has not been considered in this particular case. Because the Honorable Supreme Court held that there was a discussion or there was the scheme by, not scheme actually, the employer thought 5, 6 and 7 would be relevant for me. That if the benefit will be extended to the similarly situated workman, the same benefit would be extended to the petitioner as well. But in this particular case, because the same benefit was not extended to him, he approached the labour court belatedly. Hence, delay and laches, that has not been considered in this particular matter. Even if the case of Nadupeda Bank, that has been considered, but in this particular case, because that legitimate expectation was there, and there was a promise from the employer that the same benefit will be extended to the petitioner, what will be extended to the similarly situated persons, and when it was not extended to him, he belatedly approached the and raised the reference. And ladyship, there is one judgment. Para 7 would be relevant.
And you take this?
Yes. Because in that case also unreasonable delay was the reason. Here also the unreasonable delay has been taken into the consideration. We are of the view that in the facts and circumstances of the case, the High Court erred in not setting aside the award of labour court, apart from the unacceptable manner in which the appellant was denied the opportunity of participating in the proceedings, including being debarred from cross-examining and respondents. The labour court should not have, this is important ladyship, the labour court should not have entertained the industrial dispute given the enormous delay. The court has in several decisions held that while delay cannot be itself be sufficient reason to reject an industrial dispute, nevertheless the delay cannot be unreasonable. The decision in Prakash Chandra Sahu has reaffirmed this principle. The reason for diligence and promptness lies in the fact that the records pertaining to an employee might have been destroyed and it would be difficult to obtain witnesses who would be competent to give evidence so many years later in the labour court wishes to hold a further inquiry into the matter. In the present case, the delay of 13 years is unreasonable. In our case, my lord, delay of 12 years. The mere fact that the respondent was making repeated representations would not justify his raising an issue before the labour court after 13 years. In any event, the last representation was made in the year 1983 and the industrial dispute was admittedly raised in the year 1986. The lack of diligence on the part of the respondent is apparent. Ladyship, in the writ petition also, the delay has been explained from 2000 to 2005 when he was dismissed from the service. But thereafter from 2005 till he raised the dispute, it has not been justified.
He raised dispute in 2018.
Yes.
This is WPL number 5248 of 2019. The learned counsel for the respondent has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2008 bracket 217 SCC 627 and has submitted that and has referred to paragraph 7 to submit that in the said case the industrial dispute was raised after delay of 13 years, which was found to be unreasonable, and it was also observed that the lack of diligence on the part of the concerned respondent was apparent. The Honorable Supreme Court also held that the reason for delay for diligence and promptness lies in the fact that the records pertaining to an employee might have been destroyed and it would be difficult to obtain witnesses who would be competent to give evidence so many years later. If the learned court wishes to hold a further inquiry into the fact, the learned counsel has also relied upon the judgment, has also distinguished a judgment relied upon by the petitioner reported in bracket 2001 bracket 26 SCC 222 and has submitted that and has referred to paragraph 566.
I do not have.
Yes.
I have written on
You told it, yeah.
Yes, yes. ऊपर में भी लिखते हैं leadership paragraphs I have relied side में लिखा होगा and the
Paragraph-
paragraphs relied by
Paragraph
the
5, 6 and 7. To submit that it was observed therein that it was not a case that the appellant woke up at the end of 15 years to raise the industrial dispute, and the delay and the circumstances under which the dispute was raised has been explained. She submits that in the present case, the petitioner, the concerned workman, was dismissed as back as in the year 2005. 2005, correct?
Yes, leadership.
2005, and there is no explanation for not raising the dispute in 2018, till 2018. Rather, the workman tried to raise a dispute on the basis of some circular
Yes, that is circular.
2012.
of the year
2012.
2012. That's it.
This ground even 2012 circular ground has not been taken by
It is
the
not there in your.
Not at all. It is an afterthought that this circular the petitioner came hold of
The
it.
last sentence of that.
And
Order
that's-
reserve post for judgment on Monday. तो हम कुछ लिखाए थे तो क्या ही करें, अब तो आप लोग कुछ ध्यान नहीं जाते.
Grateful.
तो बोलिए एक बार 2001-6 SCC का पैराग्राफ 10 भी थोड़ा
There is no end to it. थोड़ा सा LPA में भी दिखाने के लिए आप लोग छोड़ देते हैं. चलिए.
Coming Monday.
Coming Monday. I've already dictated. So I'll pronounce it and upload it on the same day.
From Teddy List Item 5, the LPC 5805 of 2017.
I filed an IA raising preliminary objections. So kindly take that IA number 11465.
Case your ID.
There are two objections which I have taken in
IA
this.
number
IA number 11465.
of
24.
24.
They
Are you
basically,
ready with the IA? Yes, Counsel.
correct. I have not filed any reply, you know, but they
It
are
can't be
naturally,
piecemeal, no? If
they
you
are
want to,
making.
if you want to file a response, you file it. If you are otherwise ready, if it is born out of record, you can act.
आउट ऑफ रिकॉर्ड ही तो ये कर रहे हैं, लेकिन अगर ये टेक्निकलिटी बिकॉज ह्यूज अमाउंट है
टेक्निकलिटी की बात नहीं है, 34 होगा कि 226 होगा इसकी बात है. तो ये टेक्निकल है.
नहीं तो है
It is absolutely jurisdiction.
यस
It is not technical. You tell us. If you want to file reply, I don't have anything to say. But once he starts argument, then we will not permit you.
Actually, I don't want to take any chance because IA is there and this is the only case you know I am doing of this client. You are stating the party. So let me see instruction. I am ready on merit. I can give you my
I
merit
don't
also.
want to say anything.
But I just don't want to take any chance.
We will not
If
have,
there is
we will
something in
not
the
hear
idea.
such a matter
Yes.
piecemeal in a
Yes,
piecemeal
yes.
manner. So if you want to file a response, you file it.
Yes.
That's your choice completely. I don't want to say anything more.
But देख लेते हैं कुछ.
देख लेते, पूछ लेते, नहीं देख के बताइए रिप्लाई फाइल करना है कि नहीं.
रिप्लाई फाइल करने टाइम दिया जाए इसलिए कि वो बुलाना पड़ेगा मिजोरम जो है वहाँ से कॉल करके बुलाना पड़ेगा.
कितना टाइम चाहिए आपको रिप्लाई फाइल करने?
मिनिमम 4 वीक्स तो चाहिए होगा.
If they want to file a reply, we can't stop them.
Yes.
Let them.
They can.
Counsel for the parties are present. Counsel for the respondent has submitted that IA number 11465 of 2024 has been filed on the point of maintainability of the present petition.
On various grounds.
He has submitted that the preliminary objection may be taken at the threshold. Counsel for the petitioners prays for 4 weeks time to respond to the indemnity application. 4 हफ्ता कब खत्म होगा? Post this case on opening day, 2nd of January. The reply should be filed by 20th of December. Mr. Anil Kumar, could you find out, is there any modality by which it can be resolved?
So far as the circular is concerned, the electricity, the railway has been excluded.
Or data has been excluded?
These are the two circulars which my government has taken.
He says that it is
Yes,
excluded.
it is excluded. It says about exclusion of railways, income tax, custom and excise. So these are it. In second page, clause 3.3. Firstly, it was applicable to the commercial contracts, and secondly, there is an exclusion.
You see, in that case, we will not decide the commercial dispute. I can't go into so much of accounting and detailing.
So,
You have a remedy
Your
of the
Lordship may
commercial code.
hear me
But there is no
only
question.
for 5 minutes.
You see, I am not able to. For you, it might be very simple because you must have understood it better. But it is for me, it appears to be purely accounting. Applicability of which circular, whether it is applicable, not applicable. You see, there are two things.
I'll only take 5 minutes, not more than that. I'll summarize and whatever Your Lordship directs will be absolutely fine. I'll show as
And
to
there is
how.
a reason for that. There is
Yes.
a reason for that. Your commercial suit will also have a pre-mediation.
Yes, there is.
It could be possible that in the pre-mediation the matter gets settled.
Yes, well, that is the course which
That
would have to
is
take
mandatory.
That is mandatory requirement, that can be done.
Your Lordship may only hear me, I'll only take 5
You
minutes.
formulate
I,
your
if I say 5 minutes, I'll not exceed even for 1
Because I
minute
was
more.
just, it is too much of a
I'll be very specific and to the point, Your Lordship. I may repeat only 1 or 2 annexures, otherwise I'll
You just make
basic
your
challenge is to annexure demand made in annexure 5 and annexure 7. Now annexure 5, suddenly a demand of rupees 2 crores and odd is made, and then by annexure 7 that is enhanced to rupees 5 crore.
for the
Firstly-
same period. For the same period,
For next period, it also includes the period of the
you tell
earlier.
us the annexure 5 relates to which period?
It relates from therefore to support their demand they have annexed a chart which shows that their demand is right from 1953-54 until date.
Till date means what?
Till date means, Your Lordship, the date of 1920.
19.
Yes.
And 5 crore from 1950.
5 crore they have not annexed any chart. They simply say that you have not paid a sum of rupees 5 crore and therefore you evict. Because I have not paid a sum of rupees 5 crore, therefore you evict.
Okay,
No
what is the
other
date
reason
of
is
this
assigned.
annexure 7? Date of annexure 7.
This is 5th of January 2021.
5th of January 20.
This is annexure 7.
Let us have a look at annexure 7 and 5.
Page 44. The date of the 2 letters may kindly be seen. The first one, annexure 5, is dated 25/8/2020.
Yes.
Page is 40, and then the total amount claimed is 2 crore 64 lakh 67,320. So I'll show how arbitrary this demand is. Then Your Lordship may see the arbitrariness that immediately after 3-4 months, another letter is issued on 5/1/2021, and it says that quit notice of so and so due to non-submission of license fee amounting to rupees 5 crore 15 lakh 93,620. Immediately after 3-4 months. Absolutely no reason shown as to why suddenly an amount of rupees 2 crore and odd was enhanced to rupees 5 crore and odd, and no chart whatsoever is annexed with this annexure 7. So the arbitrariness at least.
Where is this quit notice? This is your response. Page
No,
45
this,
is the
and
response.
page 44 itself.
Page 40.
44 itself they say
This is
the
without
subject
any
is
detail.
quit notice against HPCL petrol pump at Dhanbad due to non-submission of license fee, an amount amounting to rupees 5 crore at so and so. And then in reference to the above, it is directed by so and so. His letter under reference that quit notice against Green View Petrol Pump Dhanbad may be issued as the outstanding license fee could not be deposited by the petrol pump authority. So because they say that I have not deposited a sum rupees 5 crore 15 lakh and not, therefore quit notice is being issued. Now coming back to the arbitrariness of the annexure 5, absolutely very on the basis of the chart itself, if I can show that I have a case, then Your Lordship may see. Now Your Lordship, the basic difference which I will show, that Your Lordship by annexure 1 I had shown on the last occasion also, that Annexure 1, they themselves say, annex a chart where
You
they
just
say
come to
that
page number 47.
page,
This is dated January, Annexure 8 is dated 8th of January 2021. Right?
Annexure.
8. This is 8th of January,
Yes,
Annexure
yes.
8.
This
8th
is
of
obviously in
January
response to
2021. That's right.
their letter.
And then this is your representation against whatever demand they have raised.
Yes,
And then you sent it through speed post on 12/1/21. And on 15/2/2021, you filed the writ petition.
yes,
Now let us see what is your prayer in this particular
yes.
letter.
In the prayer in
No,
the writ
operative
petition.
portion, page 47. Come to page 47.
Your Lordship may kindly see the entire letter,
You
page
say, no, I have
46
seen,
itself.
I have read it, that is why I am
Yes,
saying.
yes. Page
You have
46,
raised-
firstly
You
I
have
say,
raised very serious objections with regard to the demand, the
Yes.
mismatch, etc. have been pointed out. And what is your ultimate response?
first
You wanted a
response is
hearing-
there in page 46 itself, where I very categorically quote the clause 8, where they themselves, the agreement says,
I appreciate that,
Yes.
but please see what is your request. You wanted a hearing and an appointment so that the issue could be settled.
yes,
I'll give you that. I'll give you that because at the threshold, we are not going to interpret the agreement. Let them see all the records. You also produce all the records. Let the accounts be settled. Let the clauses of the agreement be understood in the manner both of you understand. And let there be a finding. And then there is a question, why should an agreement be interpreted by this court for the first time here? And as per your representation also, you are wanting an appointment, a hearing. You wanted a date to be fixed on 11/1/21. You post it on 12/1/21. देख लीजिए. और उसके बाद यहाँ पे एक महीना बिना खत्म हुए भी आप यहाँ पे रिट पिटीशन फाइल कर दीजिए.
because I have been asked to vacate.
That's
So
why
ultimately,
you
Your
will
Lordship,
not
I
be
cannot
vacated.
be-
That much of protection will be given to you. You are not an encroacher by any means, right? But this issue between two government sectors is required to be resolved first. You just tell us. You कौन आएंगे आपके highest authority? Who will be the person who will take care of this? He is writing to
DRM
assistant DRM.
He is the superior authority. so
बताइए
for the
डेजिग्नेशन का नाम
division.
लिख के दीजिए हमको. बताइए
He
कब
must be
जाइए.
party member.
So obviously, if I have written, then I
You have written. अभी रिजॉल्व कराते हैं. बताइए 1 महीना में रिजॉल्व.
His respondent number 2 is there.
रिस्पोंडेंट नंबर 2 आप चले जाइए. अपना सारा आप खाता बही सब लेके जाइए. समझिए there cannot be any malice, right? ऐसा malice तो हम assume नहीं करेंगे. है ना? आप जाइए उनके पास समझ लीजिए. It's a big deal about it. We will notice this mismatch apparently. This is the only way.
only way.
If it is
My-
arbitrary,
Prima facie, I just wanted to show.
and
that-
as per your admission also, you have given your calculation.
I've given my
And paid.
calculation. Yes. Your Lordship, two things. Prima facie, which I wanted
इतना
to
ही
show.
आपको writ में करना है.
Yeah, I'll place all these things before him itself. But Your Lordship, in 2015-16 itself, they say that there is absolutely no nil
अरे
outstanding.
भाई वो सारी
So that is
चीजें
the-
आपका इतना डिटेल्ड
अच्छा
रिप्रेजेंटेशन
ठीक
है.
है, ठीक है.
देखिए आपने क्या किया, ये डिटेल्ड रिप्रेजेंटेशन उनको दिया, वहाँ से कुछ आपको मिल नहीं पाया. बट आई नो यू वर इन डिस्ट्रेस, सो यू अप्रोच दिस कोर्ट इमीडिएटली. यू वांटेड सम इमीडिएट प्रोटेक्शन
Yes.
आल्सो.
That
और उसी रिप्रेजेंटेशन को आपने रिट बना के फाइल कर दिया.
was-
तो आप जो है चले जाइए. ठीक है, कमर्शियल कोर्ट से बच गए. दिस इज इट. डन.
No, my lord, so far the railway is concerned, my lord, that we require the
Yes.
land,
Wait
my
for
lord,
15
because
days.
of the fact, my lord, in terms of the Amrit Bharat schemes, my lord, that the expansion is to be made in Dhanbad
We
railway
fully
station.
appreciate that.
Yes, my lord, that
You
is the
see, you
reason.
can
my lord,
ask them. There is a renewal every year.
It was
isn't it?
being after 16, my lord, it has not been
Okay,
renewed.
fine. then you can ask them to vacate.
Yes,
अभी
ma'am.
तो आपका जो भी
No,
vacation है
there are
नहीं
two
है.
aspects, my lord. So far as the present date application is concerned, one is with respect to the outstanding dues, my lord. The other is with respect to vacating, so far as the premises are concerned, the land in question is concerned. Therefore, if at all, my lord, the dispute with respect to the payment is being decided, thereafter, my lord, they should give an undertaking, they will vacate it.
They will.
There are two aspects, my lord. Therefore, the 7 days notice was given only for, so far as the recovery part is concerned, that could be made, my lord, so far as that
They
issue
have
is concerned.
enjoyed the property till date, so whatever it is, they are bound.
Therefore, I am submitting, my lord,
Irrespective of renewal.
we are in need of the land itself, my lord. Therefore, my lord, we have mentioned in our IA application, in the stay vacating petition, but so far as the requirement is concerned, the entire map, my lord, that has been prepared for the purpose of expansion of the Dhanbad railway station, that
Yes,
has
how
also
much
been
time will it
incorporated.
take to vacate?
If I am relegated to him for deciding
No,
it
no, no. You
afresh,
see, they have
then-
made it very, very clear
yes.
that they need it for a purpose.
But your lordship, that is not reflected from the notices. Here they cannot make out a new case in
That is-
their counter. The notices simply say that you have not paid a demand, a sum of rupees 2 crore and all. And then subsequently they say that you have not paid 5 crore and therefore you quit. They cannot
This is not the
supplement it by
ordinary-
way of a counter application.
It's not an
They should
ordinary
have-
tenancy.
They could have opted
dispute,
for
my
that
lord.
particular year, but that should.
You see, we'll make it clear that the entire litigation is in two parts. One is regarding vacating the premises, and the other is regarding the payment.
Yes.
is due.
Outstanding.
And there is no renewal after
16.
2016.
after 2016.
March 2016 was the last date, my lord, so far as the
March
license.
2016, there is no renewal. But the impugned orders reflect that you had asked them to vacate on account of non-payment
Yes, that
at
is.
that point of time.
Yes, my lord, at that
And
point of time.
therefore, if there is any subsequent requirement, you can take steps in accordance with it. Whatever it is,
Yes,
right?
I do.
As a railway also, you have so much of power to
Yes, my lord, we
evict
can,
anybody.
that, my lord, so far as
I
that
will
part is
observe
concerned, that should not be confined, my lord, before the DRM.
No,
only
no,
with
no,
respect
that
to
he
the
is
fact
nobody
itself.
to take a decision
Because
on
it is
that.
the requirement of the railway itself, my lord, therefore it is to be taken care of.
That's right.
Your lordship, only one last submission that if I am relegated, then this condition cannot be.
You just listen to the order. Public interest will have the prime consideration.
Then
They have, look, one fact, my lord,
before the matter is
You
decided
just-
by him,
it
just
will be
my
a
lord,
no,
we
no.
presume that he
It will-
would.
my lord, only
ask
one
me to-
fact, my lord, I will submit before your lordship, my lord, they have suppressed the fact that they have already subletted, so far as the petrol pump is concerned, which is being run by another person, and this fact has been known to the railway only when the said
it is-
retailer has given
it is-
a
it
notice
is
to me, my lord,
known since
that you have not
1980.
replied so far as our IA application is concerned.
We have brought all the letters from 1980 onwards. They
That
are
is not the ground also.
It is not a sublet.
It was
is
never
only-
been given.
Don't
He is only managing. He is
Approve.
only managing. The HPCL officers
Aap
cannot
ruk
sit
jaiye,
there.
please hold on. देखिए, or the learned counsel is appearing on behalf of the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner is in occupation of the property involved in the present case since 1953, which was renewed from by way of which was renewed by way of license every year, and the last renewal was till March 2016. And there has been no further renewal. However, he submits that the petitioner continued to occupy the property, and the cause of action, no, full stop. The cause of action arose to move this court when a letter dated 25/8/2020 was issued to the petitioner under the subject inverted comma realization of outstanding license fee amounting to rupees 2,64,67,320 on account of using railway land measuring 8,000 square feet for HPCL petrol pump at Dhanbad. And it has been mentioned that the petitioner had not deposited any amount after 2015-16. The outstanding dues was calculated up to 2019-20. A request was also made to process for renewal of license agreement as per Railway Board norms. He submits that soon thereafter, along with the said notice, a chart was given with regard to the accounts between the parties right from 1953-54. He submits that soon thereafter, another letter dated 9th of September 2020 was issued soon thereafter. Pursuant to the said letter, the petitioner issued a letter dated 9th of September 2020 mentioning therein that the petitioner had not received any demand notice since 2016-17 for renewal of license, and the demands raised by the respondent towards renewal of license were deposited in the previous years in the following manner. इसको 2011-12 से चार्ट बना हुआ है 43 में, पेज नंबर 43. The petitioner sought information on the basis of which outstanding license fee amount was calculated, which according to them was on higher side, and a request was made to raise a fresh demand towards renewal of license in line with the previously paid rentals and to enable them to renew the license. The learned counsel submits that no response was received to the said letter dated 9th of September 2020, and the petitioner was surprised to receive another letter dated 5/1/2021, wherein the demand was increased to rupees 5,15,93,621.13, and it was titled as quit notice inverted comma. He submits that it was mentioned therein that quit notice may be issued as the outstanding license fee was not deposited by the petitioner. It was mentioned that a quit notice was being issued for removal of railway land and hand it over to the railway authority within 7 days on receipt of the letter, failing which railways would be bound to evict them from the railway land as per law. The learned counsel submits that a representation dated 8th of January 2021 was issued under speed post से भेजे हैं on the speed post, but no response having been issued, they rushed to this court by filing a petition on 15/2/2021. The Learned Council has also submitted that. An interim order dated 15/3/2021 was also issued, was also passed in favor of the petitioner by observing that no coercive steps be taken against the petitioner pursuant to the letter impugned dated 5th of January 2021 till the next date fixed in the matter. An interim order was also continued by the order dated 2/2/2023. And ultimately, the matter was taken up on 28/8/2024. And now the case is being heard by the Learned Council submits that although the Learned Council submits that the action of the respondents is ex officio arbitrary, inasmuch as initially a demand of rupees 2.64 crores and odd was raised. On 25/8/2020, which was increased to 5.15 crores and odd on 5/1/2021. And the subsequent demand was not even supported by any calculation sheet. He has also submitted that against the initial demand dated 25/8/2020, the representation was made, but no response was received. The Learned Council submits that the action of the respondent railways being arbitrary, appropriate order in terms of the relief prayed for in this petition be passed. The Learned Council, appearing on behalf of the respondent, on the other hand, while opposing the prayer of the petitioner, has submitted that so far as the quantification of the dues is concerned, a chart was already provided to them along with the letter dated 25/8/2020. And the petitioner raised a grievance in connection with the subsequent quit notice dated 5/1/2021 by letter dated 8th of January 2021 with a request to fix an appointment and grant them an opportunity of hearing so that the matter dispute could be settled. They had requested to fix a date for hearing on 11/1/2021 and rushed to this court by filing the petition. The respondents have also submitted that there has been, it is not in dispute that after March 2016, there has been no renewal of license and the petitioners are in possession of the property. And there has been subsequent development in as much as the railways are in dire need of the property for the purposes of expansion.
Yes, we have
file an IA application.
And consequently, an interlocutory application has been filed,
Yes,
being
Madam.
IA number
8,000.
8301 of 2024
Yes, Madam.
for
That is-
vacating the interim order.
Yes, Madam. In para 8 we have mentioned.
The need of the railway has been reflected in paragraph 8 of the interlocutory application, wherein it has been stated that the land being occupied by the petitioner is adjacent to Dhanbad main railway station, which is required for redevelopment of the Dhanbad railway station under Amrit Bharat Mahotsav scheme in the mass public interest. And the location of the land of the petrol pump comes within the area of redevelopment of Dhanbad railway station, which was also apparent from the proposal of the scheme. The proposal of the scheme has been annexed as Annexation D to the interlocutory application. The learned counsel submits that the interlocutory application was filed way back as on 6/2/2024, but this aspect of the matter has, on the one hand, is supported by documents and has not been denied by the petitioner. The learned counsel submits that so far as the accounting part is concerned, that can be taken care of by the respondent number 2. But so far as vacating the premises is concerned, it is a distinct matter and it should be left upon the respondents, keeping them free to take steps in accordance with it. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that it is not in dispute that the petitioner, that the license was not renewed beyond March 2016 and the petitioner continued to remain in occupation of the property. Petitioner or the person authorized by the petitioner / remained in occupation of the property. The demand of rupees 2,64,67,320 was issued by the respondent railways, alleging to be dues up to 2019-20, and a request was also made to process for renewal of license agreement as per railway board norms. This letter was issued on 25/8/2020 and expired. However, in spite of the said letter, it appears that no renewal was done and the petitioner had protested against the demand by letter dated 9th of September 2020, and a request was also made to raise fresh demand towards renewal of license in line with the previously paid rentals so that the license could be renewed. Soon thereafter, a quit notice was issued to the petitioner dated 5/1/2021, asking the petitioner to remove and hand over the property within 7 days. However, the demand this time was to the extent of rupees 5,15,93,621.13, which was in turn not supported by any calculation. Although there was enormous increase in the demand as compared to that which was mentioned in letter dated 25/8/2020. The fact remains that the license still has not been renewed. The petitioner had protested to the aforesaid quit notice by letter dated 8th of January 2021, seeking an appointment on 11/1/2021, but the said letter itself was posted on 12/1/2021, and the writ petition was filed on 15/2/2021, and interim order was also obtained, was also passed by this court on 15/3/2021. And pursuant thereto, the petitioner has been occupying the property. It is not clear from the records as to whether any further payment has been made by the petitioner. This court finds that there has been subsequent development, and the railway, through the interlocutory application, has indicated that the land being occupied by the petitioner is required for expansion. This court finds that the entire aspect of the matter revolves around two issues. One is relating to eviction of the petitioner, and the other is regarding the settlement of account between the petitioner and the respondent. The impugned order revealed that the quit notice was primarily issued on account of non-payment of amount. This court is of the view that the increase of demand from letter mentioned in, from letter dated (25/8/2020) at rupees 2.64 crores and all to 5.15 crores by letter dated 5/1/2021 remains unexplained, and such dispute regarding accounting cannot be resolved through writ jurisdiction. However, the petitioner themselves had sought for an appointment for the purposes of hearing and resolution of dispute by their letter dated 8th of January 2021, and apparently the same could not be done due to the pendency of the present petition and the interim order having been passed way back in the month of March 2021 itself. This court is of the view that the matter regarding accounting is required to be looked into by the respondent number 2, upon who is also required to grant an opportunity of hearing to the petitioner. The detailed representation has already been placed on record. It will be open to the petitioner to file a fresh representation along with a copy of the writ record and all the supporting documents before the respondent number 2 within a period of 1 week, 15 days from today. Upon their appearance, the respondent number 2 shall also verify the records and give an opportunity to the petitioner to inspect the records available with the railways. The petitioner would also be at liberty to file written notes of observations which may be made by which may be found, written notes of arguments before the respondent number 2, so that the matter is ultimately resolved without any grievance. The respondent number 2 shall also grant an opportunity of hearing before passing a reasoned order. The reasoned order will be passed within a period of 1 month from the date of appearance of the petitioner. The petitioner shall appear along with the fresh representation, which I have already told you. So far as the point of eviction is concerned, this court is of the view that there has been subsequent development and the point of eviction would stand on a different, the point of eviction which has been raised through the interlocutory application stand on a different footing altogether, and the same is not based on non-payment of allegiance. In such circumstances, it will certainly be open to the respondent railways to take steps with regard to the property in accordance with eviction of the petitioner in accordance with.
Your Lordship, annexure 5 is also under challenge. So your Lordship probably has mentioned only with regard to 5 crore 15 lakh. But the annexure 5 which contains calculation 2.6 crore,
Both have been
So
mentioned.
both have been mentioned.
Both have been mentioned.
Accounting
because
दोनों
it
का
may
होगा.
not
I've
be
also
confined
no,
to
no, no,
That has
no.
been
I've
mentioned.
also
Both have
said
been mentioned by your lord.
no, the respondent number 2 shall examine the
Entire outstanding
the objection of the petitioner in connection with annexure 4. Annexure 4 है?
annexure 5
Annexure 5 and annexure
7.
7.
And one thing has been mentioned which probably is not correct, that we have objected with regard to their personal necessity also, because your Lordship has made a note that we have not objected.
Personal necessity.
They
subsequent
say,
development with respect to the
Subsequent
requirement Manoj, that is
Yes.
in public interest.
we have said that demand is not justified.
With demand they will adjudicate
Because
on
your
demand.
Lordship probably has said
Demand
that we
is
are not.
different from eviction as of now. These are two distinct. And the fact remains that the license has not been renewed.
It has not been.
So this is something which is quite serious. The
But
interim
your
order
Lordship, it
stands
is for
vacated.
them to.
Interim order stands vacated.
This case item 1 WPL 1771 of 2009.
In this case, the petitioner challenged the award wherein the reference test was refused and the award was passed against the government lordship. The reference was whether the dismissal of the Shri Vinay Kumar Singh, ticket number 9920, the government of Mrs. Telport Limited Jamshedpur by the management is justified. If not, what relief is entitled to. Lordship, this matter was admitted by the His Lordship, order dated 24/3/2021, wherein break in service was taken into consideration that the fact that petitioner was working continuously from 1994 to 2001, and deliberately there was a break in service to deny him benefit of the continuous services. Order dated 24/3/2021, the matter was admitted on this court.
The impact of artificial breaks.
Yes.
Is there any finding of the learned labour court in connection with artificial breaks?
Lordship, the Labour Court has given a finding that
Will you
the
argue in your own mind?
yes. Annexure 1 series of the petition is that the appointment and the termination letter, again the after
Where is
giving
the appointment letter?
Annexure 1 page series page Annexure 1 series page 28.
It is exhibit?
Yes.
Exhibit number?
Exhibit W.
Annexure 1 series.
Yes.
This is not the appointment letter. Where is the appointment letter?
This is only the appointment given, and again the
Where is the appointment letter? There has to be an appointment letter.
this is the office order which we have
Office
exhibited.
order. But the icons are office order.
Office
Read
order.
that order.
Office order dated 19 Feb 1994.
It is office order.
Yes.
No, this is what? Non-member, no payment. What is it?
This is the type appointment effective from 19 Feb 1994. This is the office order given to the
Oh,
government.
this is appointment.
Yes. And next page is the
Just a moment, let us see what is it all about.
Designation is pharmacist grade 1.
Where is it mentioned? Pharmacist grade 1.
Last form is the revised designation,
Okay.
pharmacist grade 1.
Okay. Then what happened?
He continued. Thereafter, you should again.
What were the breaks?
Yes, Your Worship. For that, you should kindly come to page number 180. Your Worship. I have in the WS file, there is a table made, para 6, page number 108. That the period of employment of this workman is as under. The period of employment and the ideal period in which there was a break in service for 1 day, 2 day, I have calculated it, and it continued till in the same manner till 2001.
There is a break of 67 days also.
Yes.
30 days also.
Yes.
Is it an artificial break? In 1998 there was 67 days break.
Yes. There
Isn't
was.
it?
Yes.
In 1998 there was 30 days break.
Yes, sir.
Is it artificial break?
That was created deliberately, and again I was.
30 days, 60 days.
And after that,
Artificial break could be 1 or 2 days, isn't
yes,
it?
sir. After that, in 99 days, 1 day, and again.
That's right. We have 10 days, 24 days, 20 days, 25 days. It is not just 1 day break. Just see the dates.
Yes, sir. We have made the chart. That is not disputed anyway.
Yes.
Yes. And the court has come to the revenue's conclusion that in the past 1 year, the workman has worked for only 115 days, whereas workman has performed the services of 238 days, and there is a wrong calculation made on the part of the labor code, because if the preceding 1 year used to be taken, that has to be taken from 24/7/2001 to be preceded 1 year from 24/7/2000. In that year, I have worked for 238 days, and the court has given the conclusion that the workman has worked only for 115 days, and there was a case cited by the labor code, that is Kapurthala Cooperative Limited case, wherein the workman has worked for 230 days and there was notional break, and then he was given the benefit of reinstatement.
So
the
show
court
us what is the date you are counting? What is the date of your removal?
25/7/2001.
25/7/2001. So we have to take the date till 25/7/2000.
Yes.
Right. Now show me from the chart.
Yes.
25/7/2000. What is the period?
From the below in the chart, 8th column, 9/7/2000 to 17/8/2000. In this will count.
19/7/2000.
Will count from 25/7 here. So I have calculated 1 month. From this, 6 days will be removed. And that will be 24 days. Because in this
Okay,
we
this
have
would be 24 days.
and rest is same. 24 days, 31 days, 32 days, 1 month, 1 month, 1 month, 1 month, and 30 days. If we add this comes to 238 days.
And what is the break? What is the break in between?
That is for 6 days, 20 days, 12 days, 24 days, 10 days.
Yes. You have 24 days break. You have 12 days break. 20 days break. These are artificial breaks. Artificial break is 1 day.
They were having the continuous work. They
We do
employed me
not know.
again after
This
the,
24 days break cannot be said to be artificial break. Isn't it?
so kindly come to page 130, wherein the court has held that the main grievance of Mr. V.K. Singh is that the terms of the settlement dated written has not been complied with, and he was not regularized the service of the management, and from the perusal of para so and so, it would appear that before 1 year he had worked only 115 days, in 1 year, that is 12 months, and not complete to 40 days. And it is settled law that the burden of proof regarding completion of 40 days in 12 months.
Show me, this is what I want to know from you. Show us. 240 days.
240 days is coming, 238 days is coming, and I have worked for the preceding 1 year. And when days of
238 days is
Yes,
coming.
yes.
It is still short by 2 days.
for that, there is a judgment of.
This is
Supreme Court.
whatever you say, is it excluding the period of break?
Yes, that is excluding the break.
No, 1 month, then 10 days.
That has been excluded. Ideal period has been made in separate column, and the work for the period I have worked and has been made in a separate column. 19.7 to 17.8 I have worked, that is 1 month, and from 18.8 to 17.9 I have been made idle. So that is 30 days I was made idle. So this is the ideal period on the right hand side. In the middle is the period I have worked for, and left hand side is the period.
This column you just see what kind of, I am not able to get this column only.
Perhaps I am not clear.
No, you see in the page 109 the column is very clear.
Yes.
But in page 110 it is absolutely mixed up. What is the number of days? You just tell us. You calculate please.
Yes. From
Okay.
19.7
19.7. How many days?
to 17.8.
Yes. How many days?
This is calculated as 1 month.
Yes, but it has to be less, no?
No, Your Worship. For July is for 31
For
days.
last 1 year, no? 25/7.
Huh.
So
No, Your Worship. From that 25/7 I have to calculate, and that is 24 days.
this is 24 days.
That is 24 days.
Okay, then next month 31 days.
18.9.
No, there is a break of 6 days. Then you have
No, Your Worship. Break is of 30 days actually. 17.8/2000 till I have worked. From that 18.8 I have not worked till 17.9.
I don't know.
From 18.8, from the right hand side it is given, Your Worship. 18.8/2000 to 17.9/2000 I have not worked, that is for 30 days. And after that I was reinstated on 18.9.
Okay. Alright. Then you work for 31 days.
31.
With
Again
a
I was
break.
again on
With a
19.
break of 30 days, right?
That is break of 30 days.
You see, you have to not only complete 240 days, but also it should be a continuous period of work. Is it continuous or not continuous? Maybe 25 or 2.
My argument will be leadership, that is a continuous service if I have worked for 240 days in a
In
year.
a
In a
year.
year.
Irrespective of the breaks.
Irrespective of the break.
From where do you get 240 days?
25B of the Industrial Dispute Act, definition of continuous service.
Yes.
Where a workman is not in a continuous subsection 2, where a workman is not in a continuous service within the meaning of clause 1 for a period of 1 year or 6 months, he shall be deemed to be in continuous service under an employer in clause A for a period of 1 year if the workman during a period of 12 calendar years preceding the date with reference to which calculation is to be made has actually worked under the employer for not less than, first is 190 days in case of mine and 240 days in other cases. So here it says for the preceding years you should have worked for 240 days.
Irrespective of the breaks.
Irrespective of the breaks.
So, calculate it. Calculate it. So, the number of working days comes to how many days?
As per my calculation, 238 days.
20. 1 month is 30.
Ah.
be 235 days because you have 9th of February to 10th of March counted as 1 month. It is not 30 days. February would be 28 days, isn't it?
Yes.
It will be 235 days we are more. Now you explain.
Yes.
Is there any judgment which says that 235 has to be taken equivalent to 240 days?
In the same judgment, in the award, in addition, we have cited a judgment of the Kerala Central Cooperative Limited case, and the court has distinguished that case. And in page number
Where
1,
is that judgment?
para 9, last page.
Yes.
Thus, we have considered view that the labor court was right in treating the termination of the service of the
Para
government.
9 is the learned counsel for the
Last page. That has continued. In the last page, third line. Thus, we are of the considered view that the labor court was right in treating the termination of the services of the workmen on the rendering to 30 days services with notional breaks when the work of the workman was satisfactory and other had been recruited in their place. Thus, we do not find any error apparent on the face of record.
No. If the actual period of work is 230 days, which is coupled with notional break for 1 day each, then under such circumstances, it will be taken as 240 days. But in this case, your breaks are not notional. Breaks are, 6 days, 25 days, 20 days, 24 days. Can they be treated as notional break?
These were created just to.
No, 24 days break is quite substantial.
Yes.
Okay?
So kindly come to page 130 of the judgment of the award.
Just a moment. You see, the judgment which you have cited, an innocent workman at the verge of completion of 240 days of service, if asked to quit for no fault of his, he would go ill feeling, frustration. Just a minute. You see, the services of the respondent workman was terminated on 28 May 1979 at a time when they had put in 230 days of service with the petitioner, who is a cooperative bank sentencer. The terminal action was similar to all workmen. There was no departmental inquiry, right? After they had completed 230 days, in order to ensure that they do not complete 240 days, there was a break. This is not the case here. There is a break throughout.
Is that? That
It
is
is
not.
discrete
That is not
throughout.
disputed. But after the workman was retrenched, fresh 9 pharmacist was again appointed. That means that there was a permanent nature of work which needed.
Permanent nature of work, but your work was not permanent.
That was, I was temporary workman.
Your appointment was.
If I had been a permanent workman, then I had to be a departmental employee. That's why they have violated the 25. That
Your
is my
status
case.
was temporary.
Temporary. That is given in the appointment letter itself. Temporary service. That is given temporary appointment.
Where have you stated that subsequently persons were appointed?
Yes.
From the award, not from the deputation.
So in the WS file below the labor code and para number 5, page number 108.
108 of the deputation.
State petition. I made a chart of sale of SP Sultan, date of employment 10/10/2001. In this case, this 9 period appointed.
What do you say, respondent?
Should we see his appointment? One thing will understand could not show you. If your lordship comes from backward only, if your lordship first comes to page 103. Lordship, I kindly see it is the appointment letter. Lordship, I kindly see last but 3 entries, service period. At the time of engaging him on 25th June, Lordship, we mentioned he will be engaged for
Where is
1
service
month.
period?
Lordship, this table is there, just third line from the bottom. Service period, date, month, year. So 001, one is month, 00 is
Page
year.
103.
103.
He is appointed on a purely temporary basis.
Temporary basis, that is also mentioned, temporary appointment.
Yes, mentioned odd days.
25th June, yes.
Period mentioned. Where is
Period
the period
mentioned,
mentioned?
Lordship, can say service period. Last but 3 lines from the table, your Lordships.
Last from the table. 1, 2, 3. Yes,
Just-
service period.
Service period 001 month. Now your Lordship, can see the next page.
This is
So,
1 month.
1 month. He was engaged for 1 month, and this is the separation order. After 1 month, there is a separation. He knows that he has been appointed for 1 month, and just on completion of 1 month, his service comes to an end on 14th July 2008, 25th July. Effective date, Lordship, can you see? 25th July 2001.
From where do I get?
Lordship, can you
25th
see?
June and then 25th July.
25th July.
Where is the 25th July mentioned?
Lordship, on page 104, effective date. In the top, just above the table, your Lordships. Type, their
Yeah.
type is separation, category is mentioned, temporary service, terminated,
For each period, for each time he was appointed for a fixed period.
fixed period. And he was engaged for that period on a contract. And on completion, it is not his case that one day also he worked more than for which period he was engaged. Similarly, if your Lordship goes 1 page back, page 101 and 102, if your Lordship compares, 101, your Lordship, he was engaged on 23rd March 2001. Page 101, your Lordships. Lordship, can you see period for 1 month he was engaged? It came to an end, your Lordship, on completion of 1 month, that is on with effect from
And fresh retrobus.
Yes. And from April, your Lordship, he remained out of service. Again, he was engaged in the next phase as shown in June. So, Lordship, every engagement, he was told that you are being engaged for this many days.
It is not a case of daily wager continued
No,
for indefinite
No.
time and suddenly removed.
no.
Apart from that 240 days calculation.
And 240 days also now, Lordship, the cases are clear, Lordship, that 240 days is for a different purpose. If a person engaged not in like this kind of employment, if he is engaged for 240 days, he has a right of retrenchment benefits if he is discontinued suddenly. Here he was knowing, and every time, Lordship, after the conclusion of the contractual period, he was discontinued. But 240 days, your Lordship, is no longer a law that if a person has worked, so it will not that issue will not apply in this case, but let us just give the judgment.
He was not dismissed, he was just dismissed.
No, discontinued period came to an end. It is not a case of
Upon
termination.
expiry of the period,
Yes, and he knew that for what period I am being engaged. He was told that you will be engaged for 30 days. But the matter would have been different in cases suppose I engage a person for 30 days and I allow him to continue for 5 years without any further orders. Then matter would be different.
for the learned counsel opinion on behalf of the parties. This petition has been filed challenging the award dated 8/2/2008 passed by learned presiding officer Labour Court Jamshedpur in reference case number 12 of 2003, whereby the learned court has decided the case against the concerned workman, namely Vinay Kumar Singh. The terms of reference are as follows. The learned court framed 3 issues for consideration. Para 40. It was the specific case of the workman before the court that he had joined the respondent company on 19/2/1994 on the post of pharmacist grade 1 in medical service division of Telco Hospital and had completed 7.5 years of continuous service, and thereafter he was terminated on and from 25/7/2001 by order dated 14/7/2001. And it was his further case that throughout he was kept on the roll as temporary workman, but he was doing the work of a permanent nature and worked till 25/7/2001. It was his further case that during the period of employment from 19/2/1994 to 25/7/2001, he was made idle for 1 or 2 days, and thereafter he used to be reinstated on the same post by the management, and this continued for 7.5 years. And in support of that, the workman had exhibited W to exhibit W/77, which were official orders of appointment, separation, and reinstatement issued by the management. So the case of the workman was that he has been retrenched. Now, his termination amounts to retrenchment, and such retrenchment on and from 25/7/2001, and the same was in violation of section 25F, 25N of Industrial Disputes Act 1947. No notice was served on the workman before his retrenchment, and therefore he was entitled for reinstatement with full packages. On the other hand, it was a case of the management that there was no cause of action for the government to refer the matter, refer the dispute for adjudication, as the petitioner, as the concerned workman was in temporary pool and he was not a permanent employee. It was not a case of dismissal of his service. It has, he was working on, he worked on temporary, and he worked on temporary. His service was temporary, and he had not completed 240 days of continuous service in a period of 12 months preceding the date of his discontinuation. The management had never dismissed, and he was discontinued after completion of the period for which he was employed, and thereafter his engagement was not continued. The learned counsel for the petitioner, while assailing the impugned award at the threshold has referred to the order dated 24/3/2021 by which this case was admitted and submits that it has been taken note of that there was artificial break. It was taken note of the argument of the petitioner, who submitted that the break in service which was shown was an artificial break, but in fact the petitioner had continuously worked from the year 1994. And therefore, the impact of artificial break is required to be considered. With respect to the period of working in for 240 days, the Learned Counsel has referred to Section 25 capital B of Industrial Disputes Act and has submitted that the period of work has to be counted with respect to 1 year preceding the date of termination, and there is no such requirement that he should have worked continuously for 240 days. He has referred to the period of work as mentioned in the written statement filed by the workman and has submitted that the chart indicates that from 25/7/2001 till from 25/7/2000 till 25/7/2001 till 24/7/2001, the concerned workman had worked for 237 days. However, during the course of argument, he has also submitted that the period from 9/2/2001 to 10/3/2001 has been wrongly taken as 1 month or 30 days, as the same would come to as the month of February would be for 28 days and the total period days of work would be 235 days. The Learned Counsel submits that in the judgment passed by the Honorable Supreme has relied upon the judgment passed by the Honorable Punjab and Haryana High Court in the case of Kapurthala Central Cooperative Bank Limited, Kapurthala versus Labour Court, Jalandhar, and has submitted that in the said case 230 days was considered to be sufficient, and it has been taken note of the fact that when the workman was on the verge of completion of 240 days, he was discontinued upon attaining 230 days of work. The Learned Counsel submits that the judgment, the aforesaid judgment was cited before the Learned Court, but the same has been wrongly distinguished. The award is perverse, which calls for interference. The Learned Counsel, appearing on behalf of the respondents, on the other hand, has opposed the prayer and has referred to the various letters of engagement and discontinuation of the petitioner, to which has been annexed along with the writ petition and were exhibited before the Learned Court by the workman himself, to submit that on each letter or / office order of engagement, the period of engagement has also been mentioned. it has been clearly indicated that the appointment was on purely temporary basis. The learned counsel submits that there has been not even one instance whereby the concerned workman was continued for a period beyond the period mentioned in the office order, and in order to continue the the workman's engagement, separate office order was issued on each occasion for the specified period mentioned there. The learned counsel has also submitted that so far as has also submitted that the employment being for fixed period and on the date of discontinuation of service, the period having expired, it is not a case of dismissal or termination, and therefore the provisions of section 25 capital F is not at all attractive. He has also submitted that that otherwise also the period which has been referred to by the petitioner, that is from 25/7/2000 till 25/7/2001, there has been numerous breaks which has been indicated by the workman in the chart itself, and those breaks were ranging from 6 days to 30 days, and accordingly it cannot be said that the break were of artificial nature only to deprive the concerned workman from completing 240 days of service, and therefore the judgment passed by Honorable Punjab and Haryana High Court has been rightly distinguished. He submits that the improved award is reasoned award taking into consideration all aspects of the matter, and therefore the same does not call for any interference. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the factual narrative as mentioned above are not in dispute. The chart which has been furnished by the petitioner with regard to break in service, with regard to the period of service, right from 1907-2000, has been furnished right from the year 1994, but the relevant is for the period from 1907-2000 to 24/7/2001, which is as follows. From the perusal of the said chart and upon the argument of the petitioner, it appears that during the period of 1 year preceding the date of discontinuation of the petitioner, he had worked for about 235 days, and during this period there has been break in service for 30 days from 18/8/2000 to 17/9/2000, 6 days from 19/10/2000 to 24/10/2000, 25 days from 26/11/2000 to 20/12/2000, 20 days from 2012/2000 to 21/2001 to 8/2/2001, 11 days from 12 days from 11 11/3/2001 to 23/3 to 22/3/2001, 24 days from 22/4/2001 to 15/5/2001, and 10 days from 15/6/2001 to 24/6/2001, and he was discontinued on 25/7/2001. This court finds that the petitioner had admittedly not completed 240 days, and further there are numerous break in service for long period, and therefore it cannot be said that those break in service was artificial in order to ensure that the petitioner may not complete 240 days of engagement in a year. Accordingly, the judgment which has been relied upon by the petitioner in the case of Kapurthala Central Cooperative Bank has rightly been distinguished by the learned court, and the same has no applicability to the facts and circumstances of this case. This court finds that the the concerned workman not only failed to prove his continuous period of work from work of 240 days in the preceding 1 year of discontinuation of service, rather his own case reflects numerous breaks which cannot be said to be artificial in nature. After having gone through the impugned award, this court finds that the same is a well-reasoned order, well-reasoned award. No other illegality or perversity as such has been pointed out by the learned counsel for the petitioner, apart from whatever has been recorded above. There being no merits in this petition, by considering the limited jurisdiction under Article 226 of the Constitution of India, the present petition is hereby dismissed.
Crossover case item 14, WPC 176 of 2019.
So this matter has to go.
Actually, as a counsel, a similar matter was before DB, listed before DB. Therefore, my junior.
No, we just wanted to confirm. It doesn't look nice that I send it and then I'm told that notice has been wrongly sent.
In the letter, not it will come upon me that I did not point it out. Therefore, I have come.
Okay, WPC number 176 of 2019. The learned counsel for the parties have jointly submitted that the matter relates to mining lease.
Mining lease and demand of surface rent.
A mining lease and demand of surface rent, and as per the High Court rules, the matter has to be heard by
As per the roster.
As per the roster,
Yes.
the matter has to be heard by Honorable Division Bench. Considering the aforesaid submission, let this matter be placed before the Honorable Chief Justice in the administrative side for passing appropriate, for allocating, for passing appropriate order.
Previously, these cases were being listed before single.
Yes, yes.
But now the
I was just wondering whether the amount having been quantified, whether certificate proceeding will be a separate jurisdiction. So,
Item 17, WPC 2610 of 2021.
this petitioner,
Yes, ma'am.
The prayer of the petitioner is that the land of the petitioner is acquired by the respondents without adopting any procedure of the acquisition, and also directed for auction of the mango trees which were contributed by the petitioner. The land belonged to the petitioner, as the land was gifted to the petitioner while the petitioner was a minor, as his mother was caretaker by his grandfather by registered seal deed. Thereafter, the petitioners are continued, or petitioner is continuing on that land.
counter affidavit filed.
And-
What is your stand? Just
Your Lordship, the stand taken in the counter affidavit is that it was already a government land. It has been registered in the records as a government land, and it is an inter-department transfer that has been made to the
they were in possession of the property.
no, Your Lordship. As far as the report of the Amin and the Halka Karamchari has been attached to it, they were not in possession, and this land always belonged to the government. It has been recorded as. If your ladyship may come to para 11 of the counter affidavit, Your Ladyship. that it is humbly stated and submitted that these respondents respectfully submit that the land of the Mauza such and such, Thana number such and such, Khata number such and such, area such and such, are the government land which has been identified for construction of house under PMAY scheme, and the director Nagar Vikas and Awas has given a letter by memo number such and such dated such and such to the Deputy Commissioner Sahibganj and requested him to issue a direction to the Rajmahal for demarcation of the above mentioned land. Thereafter, Your Ladyship, since it was lying with the government authorities, this land was within inter-department transfer. It was transferred to the Director Nagar Vikas and Awas Parishad, since it was identified for the construction of house under the PMAY scheme. So there's no question of compensation or illegal acquisition, Your Ladyship. Because there was a notice also that was given, a Gram Sabha was conducted, and thereafter there were no objections, Your Ladyship. And an inquiry was done wherein the Halka Karamchari and the circle officer were present, and they conducted the inquiry, and it was found that it was not in the possession and it was recorded as a government land. From para 11 onwards in the counter affidavit we have stated all these, Your Ladyship. Para 11, 12, 13 and 14.
Land possession certificate was also granted to the
Yes, that I was going to submit. Yes. And it's a 4 page 41, 42. By saying that अनाबादी जो अनाबादी नहीं है अनाबादी खाता का नहीं है. Out to that effect, they have replied that how he managed to get the LPC, we can't say. But this LPC was issued by the circle officer Rajmahal on 2 occasions, on 12/11/16 also, and on 2/3/17 also. The same thing.
Your Ladyship, as far as that part is concerned, that has been admitted in the counter affidavit that how the LPC was procured by the petitioner is still.
And so far the position is concerned, still is in position of the petitioner. So that is not.
Have you cancelled the LPC?
No.
No, Your Ladyship.
You will only say how he has procured. You will not cancel the LPC. Right? Now, what is the position on the land?
Your Ladyship, this counter was filed in January 2020.
By that time, construction was already done.
No, so far my instruction is concerned, yesterday night I have a talk with my client that the construction has not been done, but some demarcation has been done. And it is also said by my client that is some similarly type of this, some lands were also acquired by the state government and they have compensated. That has been instructed me on telephone. Yesterday night I have a talk.
There is a, who has filed the contract?
It is subdivision officer Rajmahal. Also on behalf of the circle officer 325, and the circle officer is the person who has issued the LPC by saying that it is not an Abadi land, rather it is a Rayati land and in possession of the petitioner.
In the
And now they are
contract
denying.
they say that it is in their possession. They are disputing your possession also.
They no, they have not issued so far subject to my lord's consideration and also to my learned friend that nowhere it is said that they have already dispossessed the petitioner or that it was not in my possession.
Your Ladyship, in para 25 we have stated that with regard to the statements made in paragraph 14 to 18 of the instant writ application filed by the petitioner in the reply, it is humbly stated and submitted that the same are totally false and fabricated and concocted because the above mentioned land is government land, so the question to acquire the said land does not arise. The writ petitioner has no right over the government land, as such these respondents have acted as per law and within their jurisdiction.
And in the LPC, it is a LPC certificate process is page 4, annex 4, page 41. Such a धूल जमीन पंजी 2 में मोहम्मद नवाज आजाद डिप्टी सर के नाम से दर्ज है, आवेदित जमीन रैयती है, अनाबादी खाता का नहीं है, आवेदक एकदम स्वयं जवाबंदी रैयत है जिसका लगान वर्ष 17 तक दिया गया है, लिया गया है.
Out of sudden they say that it has been demarcated as a government land. Not a single sheet of the paper has been found by the counter affidavit that under what circumstances it is said that it is a government land. Only by saying that a notification was already later was issued by the
And
Nagar department.
And the Gram Sabha was conducted and there were no objections raised in the Gram Sabha.
We'll ask the Deputy Commissioner to look into the matter.
To file the evidence.
He should look into the matter.
Yes, Your Lordship.
Because land possession certificate has been issued, it has not even been cancelled. And your authorities are acting in contrary to each other. Otherwise, right title, interest and possession cannot be decided in legal.
Certainly, that is there. I do agree.
Right, but from the records, I find that there is no communication from the Deputy Commissioner.
No.
So he can take care of it.
Yes.
He would be a neutral person
Yes,
because
yes.
there is no action of the Deputy Commissioner involved as such.
No, Your Lordship.
Correct?
There isn't.
Though I have given a representation to the Deputy Commissioner also.
Where is that?
Annex 6 page 45. The process is page 45.
And the representation is Annexure 6 series, page 46.
Yes, madam.
The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner submits that, with respect to the property involved in the present case, land possession certificate was issued to the petitioner as in the year 2016 within bracket Annexure 4, and thereafter again in the year 2017 with respect to the same land. As contained in Annexure 4/1. The learned counsel submits that the petitioner is the rightful owner of the property involved, but the concerned authority have taken steps for the purposes of transferring this land so that it can be utilized for construction of houses under PMAY scheme. He submits that if the respondents wanted to take the land, they could have very well acquired the land. He has also submitted that the respondents in their counter affidavit have not disputed the issuance of land possession certificate, but they have questioned as to how land possession certificate has been issued in favor of the petitioner. The learned counsel submits that the issuance of land possession certificate is a proper exercise conducted by the circle officer, and after following all procedure, the same was issued in favor of the petitioner. The learned counsel appearing on behalf of the respondents has submitted that there is dispute in connection with right, title, interest and possession with respect to the property. She submits that the property involved in this case is government land and there was no impediment in transferring the land for the aforesaid to be used for the aforesaid purpose. The learned counsel has also submitted that the matter can be looked into by the Deputy Commissioner, respondent number 3, who shall call upon the circle officer as well as and also grant an opportunity of hearing to the petitioner so that the records may be verified and appropriate order be passed. She has also submitted that she is not aware about the present status of the land as to whether the houses have been constructed over the land or not. In response, the learned counsel for the petitioner has stated that the petitioner had filed representation before the Deputy Commissioner as contained in Annexure 6 series, but having no response, the present petition was filed. He has also submitted that as per his up-to-date instruction, the construction over the land has not been undertaken, although certain demarcation has been made. After hearing the learned counsel for the parties and considering the nature of dispute involved, there appears to be a dispute with regard to right, title, interest and possession with respect to the property involved in this case. Further, the fact remains that the land possession certificate have been issued to the petitioner as back as in the year 2016 and 2017. It is not clear from the records. This court also finds that the petitioner had represented before the deputy commissioner, and this nature of dispute can be resolved, can be taken care of by the deputy commissioner, who shall verify the records and pass appropriate orders. Accordingly, this petition is disposed of, enabling the petitioner to file a detailed representation with all supporting documents before the deputy commissioner's Sahibganj within a period of 1 month from today. Upon filing of such representation, the deputy commissioner shall call upon the concerned circle officer and verify the records, and after granting an opportunity of hearing to the petitioner, pass a reasoned order in accordance with law. The reasoned order within a period of 1 month from the date of filing of representation. The petitioner shall file the representation and appear before the deputy commissioner on 2nd of December 2022 at 11 a.m. Petitioner and the concerned circle officer. Respondent number, who is the circle officer is respondent number 5. This petition is according to this picture.
For hearing item 18, WPC 3598 of 2001.
This petitioner.
And it should 6, page number 58. This order has been passed by the additional collector that night in RMA. It is in a peak 4595, in which the opposite party, the respondent, private respondent, to challenge the donation of land to the petitioner by the landlord under Pradhan Samiti, and that exercise was completed in the year 1966 itself by a proceeding in which the notices were issued to all the parties. That has come in the order. But after the period of in the year 1994, they have come to challenge the same. The order is
By saying that the transfer was fraudulent.
I have finished the order of the Udariya Samiti, not of the IDC.
You did Election 6, which is the impugned order.
Impugned order.
Who are you representing?
Yes.
Who are you representing?
Respondent number 8, 11 to 15.
Private respondent.
Yes.
And you claim that the property belongs to you.
Yes, madam. Our claim is that the Dan Patra has been procured by committing fraud, and another is that land has been settled to us by the original renter prior to issuance of land. That is our case.
Read
But
Annexure
Landed
6.
Court below has allowed our appeal on the ground that fraud has been committed in procuring the land.
Let us see page 58. Read it. What do you
Page number 58. This is पर उपरोक्त तीन वाद भूमि सुधार समानता देवघर के न्यायालय द्वारा विधान संपुष्टि वाद संख्या 766/2063 में पारित आदेश 26/12/66 26/12/66 order by
I don't know permitted I may give the set of
पहले पढ़िए ना इंक्लूड ऑर्डर पढ़िए फिर आगे पढ़िए
26/12/66 and भूदान बेगंधारी वाद संख्या 40/41/42 में पारित आदेश के विरुद्ध बद्री राउत वगैरह द्वारा दिए गए आवेदन के आधार पर प्रारंभ किया। विषयगत अपील सारगा अंचल के अरबीपोला थाना संख्या 120 दाग संख्या 69 एवं 2 से 7 निम्न न्यायालय में के भूदान वाद संख्या 765/1963 के मूल अभिलेख को देखा जो अभिलेख है और उभय पक्ष के अधिवक्ताओं को सुना। सभी पक्षीय अधिवक्ताओं का द्वारा उपरोक्त तीनों अपील वादों को एक साथ अपना अपना पक्ष प्रस्तुत किया। अपीलकर्ता के बीच अधिवक्ता द्वारा निम्न न्यायालय के भूदान वाद संख्या 766/1963 में अभिलेख जीतू राउत मूल रैयत द्वारा दाखिल संपुष्टि आवेदन के विरुद्ध आपत्ति आवेदन का हवाला देते हुए कहा गया कि निम्न न्यायालय द्वारा मूल रैयत द्वारा दिए गए आपत्ति पर किसी भी तरह का विचार नहीं किया गया और न तो अंचल निरीक्षक के मंतव्य पर ही विचार किया गया। अपीलकर्ता के विज्ञ अधिवक्ता का यह भी कहना है कि निम्न न्यायालय द्वारा दानदाता के इस कथन पर भी ध्यान किसी प्रकार का विचार नहीं किया गया कि दानदाता के साथ साझी के हस्ताक्षर से लिया गया है। दानदाता की जमीन के बनस्पत जिसे दानदाता पूर्व में ही बंदोबस्त कर दिया था। अपीलकर्ता के विज्ञ अधिवक्ता के द्वारा
सीधा सा बात है कि दानकर्ता had no right over the property to give in Bhudan because he had already settled the land with some people. This is the case?
this part of the case is that I had annexed the entire document which we have the Bhudan Samiti which was granted to the petitioner and the proceeding was initiated itself in the year 22/8/63 का ऑर्डर हम सेक्शन 1 सेक्शन 2 लगाए हुए देखने में। This was before the revenue officer had Bhudan case number 766/2063 in which SI report was also called for and thereafter there is order dated 13/2/64 produced the record of CI placed on the record he reports that the plot number
Where is the order?
Annexure 2 madam.
Page number?
Page number is 23.
And where are you reading?
That is entire order of the entire proceeding is there.
And what is 165? 165 of 63?
260, the case number was 766.
Yes, there is one case number 765 also. You read it just now in the order.
In the order 766 would be there.
765 भी एक जगह है second paragraph में 58 का second paragraph में correction करके 765 किया है।
Correction. निम्न न्यायालय की भूदान वाद संख्या 765 correction कहीं
ये कौन सा order है?
That was not related to. I have not seen such order.
इसी को तो देख के सुन रहे हैं दोनों को। हम बोलते से कोई मतलब 765 से कोई मतलब नहीं है 766 से मतलब है
766 कहीं
अच्छा ठीक है पढ़िए क्या है ये
हमने भी अपना जो लिखा अपीलकर्ता के विज्ञ अधिवक्ता द्वारा निम्न न्यायालय को भूदान वाद संख्या 766/63 में दी गई दिस वाज देखते
who was the donee
donee was मतलब
who was the donor first जीतू राउत
दान पत्र फाइल बाय भूदान कमेटी देवघर श्री जीतू राउत विलेज हरिपोला has donated the land described in दान पत्र to आचार्य विनोबा भावे issue notice in the 16 reyes of the concerning village to file objection. This was the first order.
16 रही है 16 CI report not received
63 CI report yet not received. Then after 13/2/64 that is the report of the CI placed in the report he reports that the plot number certain
कहाँ आप पढ़ रहे हैं
हम पढ़ रहे हैं पेज नंबर 24
24 तो वो फॉर्म है फॉर्म 2
इस इसी ऑर्डर के बाद हम लगाए हुए हैं।
इसी के ऑर्डर के बाद तो आप फॉर्म 2 दान पत्र यही लिखे हैं। पेरूस का ऑर्डर लिखा है जरा। मिसमैच है ना, रिकॉर्ड पे तो नहीं है, यहाँ पे तो नहीं है। आप लोग क्या लगाए हैं मुझे? स्टेट कौन है इसमें? आप? State is absent. Who is in possession of the property?
As per as my lord, we are in possession of the land. ऐसी रिपोर्ट में आया है कि पर्ती पड़ा हुआ था।
हम ही लोग पोजीशन में।
अब पड़ती जमीन किसके पोजीशन में होता है बताइए?
खेती बाड़ी के लिए दिया गया था इसको।
देखिए, जो चीज मेरे रिकॉर्ड में नहीं है ना, उसको आप मत ही पढ़िए। आप हमको ये बताइए, इनके फेवर में सेटलमेंट हुआ था कि नहीं हुआ?
इनके फेवर में सेटलमेंट का कहीं कोई डिग्री नहीं है। जो ओरिजिनल फाइल है, ये बुदान जो प्रोसीडिंग वहाँ पर हुआ, उसमें नोटिस भी हुआ था, नोटिस पर ये लोग अपीयर नहीं किए थे। प्रेस नोटिस या आफ्टर नॉट कंप्लाइड। लास्ट ऑर्डर 26/12/66 हुआ था, जिसको कंसीडर किया गया है अपील कोर्ट के द्वारा। रिपोर्ट ऑफ द रिपीट टाइटल ओनर हैज राइट टाइटल।
आप बताइए, आपका कहाँ है डॉक्यूमेंट रिगार्डिंग सेटलमेंट?
डॉक्यूमेंट हम लोग सबमिट किए थे, एक डॉक्यूमेंट आया है। Our case is that in the year 1993-94, they have filed a rent fixation case. Then we got knowledge about the Dhan. And that rent fixation case, my lord, liberty has been given to the private.
When the property was mutated in your favor, was it ever mutated in your favor?
No, that is immaterial. That
is after 93-94 in that rent receipt has been issued to them. Before that,
prior to 1993-94, it was being issued in whose name?
Well, can we see the
Was it being issued in your name, or it was issued?
It has appears from the order of rent fixation, my lord. We have filed some document in that lower court, my lord. And also is
396 order annexure 3(1) is
आपके पास ना डॉक्यूमेंट है ना आपके पास रेंट रिसीट है।
रेंट रिसीट जमा किए थे।
कब का है?
नीचे में
कब का रेंट रिसीट है बताइए। अभी तो नया सुप्रीम कोर्ट का जजमेंट आया है कल, नहीं पढ़े होंगे
पोसेशन के बारे में। इसमें एनेक्सर 3 में जो रेंट फिक्सेशन केस में उन लोगों का फेवर में ऑर्डर हुआ है, उसमें हम लोग माने
आपके फेवर में कभी रेंट रिसीट था कि नहीं?
हाँ, तो आया है, मैं लोग हम जमा किए हैं, लेकिन मैडम में भी परमिटेड
पीरियड बताइए।
उसका आपत्तिकर्ता द्वितीय पक्ष के बीच और विधिवत्ता द्वारा अपने दावे के पक्ष में पट्टा नंबर सचन सच साल 1353 बांग्ला प्रस्तुत किया गया, जिसमें खसरा नंबर 2 रकबा 15 पट्टा की बंदोबस्ती चतुरानंद महतो वगैरह के साथ की गई है। दिखाया गया दावे के प्रमाण में मालगुजारी रसीद मूल रैयत 8 फर्द और रसीद बिहार सरकार जमाबंदी नंबर 5 1 लगान 1 रुपया का वर्ष 1976-77
किसके नाम से है?
दिया है।
ओरिजिनल ओनर के
नहीं, इसमें दिया हुआ है जिनके नाम से सेटलमेंट हुआ है चतुरानंद महतो वगैरह।
You are representing चतुरानंद महतो।
यस वगैरह दिया पेज अनेक्सा 3 में इंटरनल पेज 3 में लास्ट पैराग्राफ।
समीर जी इसको ना कुछ डॉक्यूमेंट्स एकदम पता नहीं चल रहा है। इसको जो है सबका तो टाइप कॉपी लगता है फाइल में। कहाँ है रेड रिसीट को कॉपी दिखाइए।
रेड रिसीट का नहीं है वो हम खाली जो लोअर कोर्ट का ऑब्जर्वेशन आया है उसी को हम पढ़ रहे हैं। अनेक्सा 3 में पेज इंटरनल पेज 3 में
एनेक्शन 4 हम लोग लगाए हुए हैं। एनेक्शन 4 हम लोग का रेंट रिसीट पेज नंबर 37।
भाई आपका म्यूटेशन जो हुआ उसके पहले किसके नाम से था?
इसके पहले वो दिख रहा है जो देखिए ऑर्डर डेटेड 7/12/5 जिसके खिलाफ में अपील फाइल हुआ जिस ऑर्डर के खिलाफ उसी ऑर्डर में सब आया है कि किनका चल रहा है
7/12/5
जी
उसी को हम पढ़ रहे हैं।
एनेक्शन 3
एनेक्शन 3
उसी को हम पढ़ रहे हैं। पेज ना इंटरनल पेज 3 का बॉटम
इसको हम
लास्ट
पढ़ते हैं। ये जिस ऑर्डर में 5
रनिंग पेज बताइए।
3 रनिंग पेज 33 होना चाहिए मैं नहीं पढ़ा है
ऑर्डर
33 3 में इंटरनल पेज 3
टू रीड द ऑर्डर
बॉटम में
रनिंग पेज बताइए ना।
अपील करता विपक्ष के दावे के पट्टा संख्या
29/3
बंगला पशु के लिए काम का
96 का ऑर्डर है। 27/12/95 का ऑर्डर है। और आप कौन सा ऑर्डर पढ़े?
यही हो
95
95
25/12/95 का ऑर्डर।
पेज नंबर 27
दिस इज इन योर फेवर।
नहीं फेवर में नहीं इसमें मेरा आया है कि हम क्या हम डॉक्यूमेंट जमा किए हैं उसीलिए हमको लिबर्टी दिया गया कि अल्टीमेटली ऑर्डर हुआ कि कॉन्फर्मेशन हुआ है डोनेशन का उसलिए लिबर्टी दिया गया हमको कि आप चैलेंज कीजिए कॉन्फर्मेशन ऑर्डर डोनेशन इसी
तो आपने चैलेंज किया
चैलेंज किए वही उन्हीं का पासिंग के लिए आया मेरे फेवर में आना हुआ कॉन्फर्मेशन सेट असाइड हो गया ऑन द ग्राउंड दैट दान पत्र हैज बीन प्रिपेयर्ड ऑन द बेसिस ऑफ by committing fraud that has been challenged by the
what was key before the lower court matter 7/12/95 के ऑर्डर के खिलाफ ही इंप्यून ऑर्डर पास हुआ ये ऑर्डर मेरे फेवर में हुआ उसके बाद इन्होंने अपील फाइल किया thereafter appeal was allowed in their favor
there is a checkered history of this एक तो लिस्ट ऑफ डेट्स फाइल कर ली वैसे भी 4:30 बज रहे हैं अभी तो नहीं डिसाइड होगा लेकिन लिस्ट ऑफ डेट्स आपको फाइल कर
इसमें जजमेंट है फ्रॉड के ऊपर मतलब कि कोई यदि फ्रॉड से कोई ऑर्डर मिलता है तो उसका मतलब नालिटी
लिस्ट ऑफ डेट्स चाहिए ना फ्रॉड कब हुआ Learned counsel for the parties are present. They have argued the case at length as the court time is over. The matter is directed to be listed on next Thursday for further hearing to be taken up at 2:15 under the heading of final disposal. In the meantime, and latest by Tuesday, the counsel for the parties are directed to furnish list of dates and synopsis of argument. ये भूदान में अपने वाला जो वो बुक रहता है एक आध केस हम लोग पहले भी किए ठीक है 2001 का मैटर कितना साल हो गया स्टेट नहीं है यहाँ पर स्टेट बहुत अच्छा इसी सेंचुरी में डिसाइड हो जाएगा
Your Lordship, there is a matter for hearing at serial number 20, Your Lordship. And the pleading, Your Lordship, may be listed after 10th December, Your Lordship. My senior Mr. Sinha, he'll give
अभी
me.
कहाँ 10 दिसंबर के पहले टेकअप ही नहीं है।
वो सप्लीमेंट्री में आ जाता है हीयरिंग के मैटर्स इसलिए.
कोई बात नहीं, आएगा तो if your senior is in trouble, there is no reason that I will not accommodate you. Then I will hear you for some time, so get ready. Okay? हो सकता है आपको उनके बिना सुने ही आपका केस अलाउ कर दें. Possible? You argue well, you get ready. So you have an opportunity. So you wish that it is taken up.
Actually, Your Lordship, there's a wedding in the office next week, that's why.
Wedding in the office. पूरा ऑफिस किसी से शादी कर रहा है.
Office के associate.
कौन है एसोसिएट जिसकी शादी हुई है,
सोनल
जिसका
Your
कार्ड
Lordship.
हमारे तक कभी तक नहीं पहुंचा. Who?
Sonal, Your Lordship.
Oh. कोई बात नहीं. देखते हैं. We will adjourn. We always accommodate. These are very old matters. We want that these matters should be taken up.
Yes, Your Lordship. We also
Dump
want
किया
to-
हुआ रखा हुआ है.
Yes, Your Lordship, this is a very old
Let
matter,
it
2000.
let it see the light of the day.